So there's been a lot of talk in the news this week about the IVF ruling. It's important to sort of read it for ourselves. We don't have to read the whole thing. It sort of it has a theme. You'll see, and there's some reports about how it invokes God, and that's partially true, but it's also not in the majority opinion. It's a consenting opinion or a concurring opinion. Excuse me, consenting. Well, dissenting, concurring opinion. So the fact that it's from Alabama should be the first grown. Yes. So where would we expect? Would it be more remarkable if this came out of New York or California? Yes. If it came out of Washington, D.C., yes. It's the Supreme Court of Alabama ruling, I think affirming a lower court ruling. And you'll see what it does. It sort of just jumps straight to what the definition of unborn is, and then expands that definition to encompass in vitro fertilization embryos. This court, says Justice Mitchell, has long held that unborn children are children for the purposes of Alabama's Wrongful Death Act. Okay, so parents can sue over the death of a child. The central question presented in these appeals involve the death of embryos kept in a cryogenic nursery. The question is whether the act contains an unwritten exception to the rule that extrauterine children, that is, unborn children who are located outside of the uterus at the time they are killed, versus, being killed or being terminated in the uterus, or outside of the uterus in IVF. Under existing black letter law, the answer to the question is no. The Wrongful Death of a Minor Act applies to all unborn children regardless of their location. This does nothing to advance the question, though. You're just saying unborn children. You now have to go through and justify legally the definition of unborn children and expand that to include IVF embryos. So let's see how they do that. The plaintiffs in these consolidated appeals are the parents of embryonic, let's call them embryos. I'm going to try to avoid using the conclusory terms in the decision. Each of which was created through in vitro fertilization and, until the incident giving rise to these cases, had been kept in a cryogenic nursery while they awaited implantation. They use the word alive. The LePages are the parents, the Tripps are parents, and the Burdick Isons are parents. Each set of parents went to a fertility clinic. They participated in the process. The plaintiff's IVF treatments led to several embryos, which I'm assuming don't get cryogenically frozen unless they become, the definition of embryo is the fertilized egg. So once they become embryos, then they're fertilized, is what I'm trying to say. So they are kept in the cryogenic nursery, and the center kept the cryogenic nursery secured, but a patient managed to wander into an unlocked door or something and then removed several embryos. The sub-zero temperatures were compromised. The patient dropped the embryos on the floor because the sub-zero temperatures burned them, and the embryos were destroyed. They use the word killed. The plaintiffs brought lawsuits. Forgetting all of the history, all of the procedural history, they're now reviewing this at the Supreme Court stage. Were those embryos people for the purposes of a wrongful death lawsuit? And the court writes, the parties to these cases have raised many difficult questions, including ones about the ethical status of extrauterine children, the application of the 14th Amendment, and the public policy implications of treating extrauterine children as human beings, which I think is the actual big deal here. But the court today need not address these questions because, as explained below, the relevant statutory text is clear. The Wrongful Death of a Minor Act applies to all unborn children without limitation. Again, this word unborn children, that doesn't encompass embryos automatically. You're going to have to expand that definition, that a fertilized egg is now a child. That's never been proven in this case so far. That language resolves only the issue on appeal, or the only issue on appeal with respect to the wrongful death claims. Okay. So the parties agree that an unborn child qualifies as human life, a human being, or a person throughout all stages of the unborn child's life, regardless of viability. Okay, so this is the life begins at conception thing. We don't care that life can't survive. That's not a measurement according to this. So the court is starting from a conclusion that the embryo is already a human being. So before this IVF ruling, they had already established in the court's mind that this embryo is a human being. And the question was not, is the embryo a human being? The question was whether a IVF embryo in cryogenic stasis outside the uterus is a human being. So you follow, they didn't actually make that big of a leap. They already ruled the previous horrible thing. And now they're ruling this new horrible thing. And why I'm concluding it's a horrible thing, I will definitely get to that, because this ruling has the opposite effect of what they're wanting to do. And it's pathetic. It's stupid. It is an affront to the very, very beliefs that they cite. They cite to religious beliefs in the concurring opinion, and this is a violation of those religious beliefs as well, because I was raised with those religious beliefs, so I get to say what I think about their religious beliefs when they violate them in a way that visits their violation upon others. That's a big deal for me. I do not like to see that. The question on which the parties disagree is whether there exists an unwritten exception that the unborn children who are not physically located in the uterus, in a biological uterus, at the time that they are destroyed or killed. The defendants argue that the court should recognize such an exception because they say an unborn child ceases to qualify as a child or person if that child is not contained within a biological womb. So you can see they did not have to go far. They already decided that the embryo was a human being, regardless of viability. That they said that in the 8th page or 7th page here. So it's really not that far of a leap to then say that the embryo is a human, even if it's outside the uterus, because they don't care about viability. They don't care about what we're going to get to, the philosophical problem here. The civilization, societal, and philosophical problem here is beyond the intellectual capacity of these judges. The plaintiff argues that the proposed exception would introduce discontinuity in Alabama law. Go figure. They contend that the defendant's proposed exception would deprive parents of any civil remedy against someone who kills their unborn children in a partial birth posture, that is, after the child has left the uterus, but before the child has been fully delivered from the birth canal. Okay, so they're saying this is a slippery slope, and if you allow embryonic cells to be destroyed, then you're going to allow partial birth abortion. So that right there is an extreme position and an extreme misstatement of what the parents here are doing. I would go so far as to say that is a fraudulent statement. The plaintiffs are trying to get something they don't deserve by scaring people into thinking that the people wanting IVF treatments are wanting this. The plaintiffs also argue that the defendant's proposed exception would raise constitutional questions. One latent implication is that under the defendant's test, even a full-term infant or toddler conceived through IVF could be terminated. Oh my God. They really went all the way down the rabbit hole. That if we don't protect, life at the moment of conception, then we're going to have partial birth abortions everywhere. These are weighty concerns, but these cases do not require the court to resolve them because, as explained below, we can just simply say unborn children are children without exception. So that's what they do. I don't know if we need to go further into this. Besides, I do want to show you one more thing from the concurring opinion. The defendants ask us to recognize an unwritten exception for extrauterine children in the wrongful death context because they say our own precedents compel the outcome. They argue that the court's precedents require complete congruity between the definition of who is a person and under criminal law and under civil law. Okay, so they're saying the defendants, the IVF treatment facility, are saying that if you can't kill an embryo under criminal law, then we can't kill an embryo under civil law. That extrauterine children are not basically not humans within criminal homicide laws, and as a result, extrauterine children are not protected by the Wrongful Death of a Minor Act. So you already had an uphill battle going into this case, that the court had already decided that life begins at conception and that the state has legal rights over the embryo in uterus or outside of uterus the moment that the the moment that the sperm enters the egg. So it's really not a controversial decision in the sense that they said something weird. They just expanded the definition to include extrauterine children. Then the Chief Justice writes about the definition of the sanctity of unborn life. The Alabama Constitution does not define the sanctity of unborn life, but God does. Sanctity is defined as holiness of life and character. If you thought I was joking, no, here it is. Here is a chief judge of the Alabama Supreme Court invoking God in their decision. And I'm not just going to show it to you once. There's a lot of them. So godliness is the quality or state of being holy or sacred. Inviolability is sacred objects, obligations, or rights. I don't know why inviolability is listed there as well. Recent advocates of the sanctity of life have attempted to articulate the principle on purely secular philosophical grounds. Such advocates have preferred to use the term inviolability rather than sanctity in order to avoid what one scholar calls distracting theological connotations. But even though inviolability is certainly a synonym of sanctity, and in that the meaning of the two words largely overlap, the words cannot simply be substituted. This kind of acceptance is not foreign to our Alabama Constitution, which invokes the favor of the Almighty God, capital G, that's Allah, that's Jehovah, that's the Christian God, that's the Islamic Allah, and that is the Jewish Jehovah. That is the same God. I am not making anything up here. The Alabama Constitution's recognition that human life is an endowment from God emphasizes a foundational principle of English common law, which has been expressly incorporated as part of the law of Alabama. So, okay, forgetting for the moment that we have the First Amendment, the government, the Congress shall make no law abridging the religion or establishing a religion. And that the 14th Amendment applies that to the states. So Alabama shall make no law establishing a religion, right? Or the opposite, infringing on anyone's right to have their own. And here yet they have chosen a particular God from a particular canon, from a particular religion. There's millions of other religions, there's millions of other gods, there's millions of people who believe in no God, but we've chosen one and raised that one above the others. But that's okay. William Blackstone declared that life is the immediate gift of God, a right inherent by nature of every individual. He later described the human being as being the immediate donation of the great creator. Only recently has the phrase sanctity of life been widely used as a shorthand for the general principle that human life can never be intentionally taken without adequate justification, etc. So he uses a lot of religious imagery in here to argue that we need to protect human life for these religious reasons as well. And that, life is sacred, and therefore even a fertilized embryo is sacred. And the reason that I wanted to bring all this up today is because we often don't get a chance to talk about the philosophy of law as a guiding hand in what the law should be. So many people just see the mechanical law just mechanically operating and don't understand how it got there. They don't understand the principles behind how it got there. When you look at how gears and clockworks work, you don't recognize the mechanical, physical principles that makers have learned and passed down for hundreds and thousands of years. We just see the mechanical inner workings. So the philosophy of law is sometimes very interesting. One of the questions that I did not see answered in there in any way is a very, very important philosophical question of law. Bring it in. I'm trying to. It's a wheelie chair. Do we want to see more of this behavior? Is this the type of behavior we would want to see widespread in civilization? So, when considering a Supreme Court, a panel of Supreme Court justices, when they are considering the ins and outs, the issues involved with this decision, they need to consider philosophical questions of law as well. If they make this decision for these individual people, and then this enables the widespread, the widespreading of this behavior, that everyone adopts this behavior because the court has endorsed this behavior. Is this the kind of behavior we as a civilization would want to see more of? So, knowing that you have protected an embryo at the moment of conception, let's go back all the way to there. I'm going to play hyperbole. You've heard hyperbolic people before saying things that make no sense. There is actually a reason to use hyperbole. There is a way to use hyperbole as a tool, and I think it's awesome, but nobody knows how to use it, so I keep trying to tell people how to use hyperbole. You use hyperbole to define the line. Where is your line? You have to think of extremes. You don't go to those extremes. You think of the extremes and use them philosophically to define boundaries for yourself. So let's do the Alabama Supreme Court. We'll do them, and then we'll do the other side. The Alabama Supreme Court believes life begins at conception. A man and a woman, or sperm and egg, touch and become fertilized. They believe that's now the place where the state of Alabama has legal rights over that child, that embryo, separate from the mother who hosts it, separate from the IVF test tube that hosts it. That cluster of cells has its own legal recognition and rights. So if a woman gets pregnant, the state becomes part of that immediately. The moment that she is pregnant, I believe she doesn't even know she's pregnant at the time. I'm assuming she knows she's had sex, but she doesn't know she's pregnant at the time. And then that moment, the state suddenly has rights over something inside her body, and she is now legally responsible for hosting that bit of cells. So Alabama Supreme Court says life begins with conception. That's where they are. That's where their line is. On the other hand, I had a very meaningful conversation with my wife this morning. I said, where is your line? Would you endorse killing a child after birth? I no longer want this child. I'm going to kill this child. I'm going to terminate the pregnancy after birth abortion. Okay, yeah, okay. I think we're all of us, 100% of the people can agree you don't terminate a child after birth. That's a fully developed, viable child. That's a person, that's a human being with rights. The state protects that. I'm on board. Everybody is on board that you can't terminate a pregnancy after the child is born, okay? And then you saw kind of a absurd, ridiculous position inside that majority opinion that this IVF ruling, if they did the other way, would lead to abortions where they take the child out of the uterus partially, abort it, kill it, and then it's not a violation of anything. I'm sure that most of us can agree that, except for actual actual medical reasons, like killing a child in the middle of birth is probably not also something that should be legal. So, I'm on that side of the line, and that for most of us, I'm going to guess that most people who don't agree with the Alabama Supreme Court, that most of us would say that there's some period of months of pregnancy where, after the child is viable, it could live on its own. After the child is so old in the womb, at some point, 6 months, 7 months, maybe it's earlier for you, maybe it's later. That's totally okay. But that somewhere in there is your line. That's what we're doing with the hyperbole. We're saying there is something that's far over your line. There is something that's slightly over your line. There is something that's under your line. I don't agree with this 6-week abortion ban because it's intentionally crafted to make it so that the pregnant woman cannot have an abortion. she has very short time window to discover that she's pregnant and then decide what to do. So I believe in the viability restrictions that were on abortion before. But the Alabama Supreme Court, of course, believes that that life begins at conception, and you don't have the right to terminate your pregnancy, even that moment. Like even if you knew right then and there, you couldn't terminate the pregnancy. So now that we sort of have an idea of where your line is, we can go back to that question. If this ruling were adopted widespread, and other courts and other people and other IVF clinics and everything took this ruling and adopted it and applied it, and everyone now does this. Everyone does the embryos are full human people with rights. Mothers are subservient to the state because the state has to protect the child that is an embryo, either inside the mother's uterus or in the IVF test tube or whatever future technology develops. So if everybody did that, what would the result be? Would the result be the kind of thing that we want to be widespread? No. And that's what they didn't want. They wanted the opposite. They were trying to say, we want more children. We want to protect children. We want to not sin against God, according to the one justice. And this is the opposite of that. First, invoking God, absolutely ridiculous. Absolutely ridiculous to, in a country founded on the principles of law as separate from the principles of God, in a religion where even their savior, Jesus Christ, said, render unto Caesar what is Caesar, render unto God what is God's, who urged people to obey the laws of men, but also obey the law of God. This is a violation of that. It's just absolutely ridiculous for a religious person to cite a religion that says judge others not, and then he's judging others based on his religion. It's ridiculous. You should just disregard that judge. You should disregard this opinion. Except, of course, we live in this weird time where now there are Supreme Court justices of the United States, the federal Supreme Court justices, who also hold this view. So you could actually have something to worry about here. But the philosophy of law is, do we want to see more of this? Do we want to see IVF treatments treated as people inside those test tubes? Do we want mothers to be controlled by the state immediately upon getting pregnant, even before they know they're pregnant, because the state considers that embryo to be a full legal human being with full rights and protections of the state and everything before it is viable, before the mother knows before she's pregnant, before the mother knows it's there? And no, of course, no, they don't want that. They want this to lead to more people being born, and it's going to lead to less people being born. It's the ridiculousness of choosing strict positions without any flexibility for the details involved. Obviously, there are different stages of human life. Anyone who actually studies these things, even at an elementary school level, knows the sperm and the egg and the embryo and the zygote and the different stages of development, and eventually it has a heartbeat, and eventually it has little hands and feet, and you see the little black eyes and the sort of soft pink tissue, and it grows really freaking cool, and we could all be on board with how cool this is, instead of saying, nope, that whole thing is one thing, no stages, no definition, no details, because I have a religious belief, and the only way to get my religious belief, in charge of you, is for me to say that this is life beginning at conception. It's just someone wanting their beliefs to be imposed on you, wanting to control what women do with their bodies. There is no scenario. Here's a good scenario. I spoke about this earlier with my wife. What do you think the effect is on a child when the mother doesn't want it? I'm not saying it's not possible for a mother to, come around and be a good mother. Once again, do we want the widespread effect of children being born to mothers who did not want them? No, we do not want that. We do not want many, many children, thousands of children, millions of children being born to mothers who couldn't get abortions. What about those embryos that are currently in IVF? Those are all people now. I just thought of this. Those are all people now. There are probably millions of embryos in IVF treatment that are all people now. What happens to those clinics who decide, I don't want anything to do with this, I'm out? They've got millions of people in their possession. What is that now? So is this sort of thing you want to see widespread? No. No, the Alabama Supreme Court is absolutely ridiculous. I never thought that I would be smarter than Alabama Supreme Court justices. When I was a kid, I used to look up to people like Clarence Thomas and Supreme Court justices and stuff like that because I was raised in that environment. I was raised in a very, very right-wing future MAGA household. And I got out, thank goodness. But for a time there, I thought Rush Limbaugh was the shit. I thought Clarence Thomas was awesome. I thought George Bush was a great president. And I thought Clinton was terrible. He kind of was terrible, but not as bad as the others. We definitely don't want to see more of this. We definitely don't want IVF clinics to suddenly be holding thousands and thousands of actual children, of human beings, as opposed to having embryos. What the Alabama Supreme Court, Alabama lawmakers could do is define these things. Instead of the willful blindness to these things, they are being intentionally blind so that they can get their way. It's a pretty common thing. I don't want to run out of overtime. And instead, what they've done is ruled in pretty much the opposite way that they meant to, because they forgot to address an extremely important question of philosophical law, of law philosophy. Do you want this to be widespread? And they didn't think of what would be widespread after their opinion. They thought, hey, I'm doing my religious thing and I'm protecting human life, and life is the sanctity of life is important. You saw him using the religious words there. Life is meant to be protected at the godly level. So I as a Supreme Court justice am going to do that. Full stop. Forgetting about the consequences. Forgetting about his own religious teachings that told him not to do that. It's a personal, selfish power grab thing that seems to come from, well, Alabama and old white men and Supreme Court justices these days. So let me know what you think in the comments below. They would do better reducing abortions with better sex ed and contraceptive ability. Yes, absolutely. It's been proven time and time again that if you actually care about the unborn child, you need to provide the social services that those same people hate so much. That's the real weirdness of all of it. Is I'm on board with protecting the unborn child and protecting the mother. Okay, let's. How are you going to protect the child from the moment of conception all the way up to the moment it's 18? How are you going to help the mother from the moment of conception all the way up to the 18? Let's define how we're going to do that. It doesn't mean you have to give $1 million to the mother, but it does mean you should carefully define what do you need to do each step along the way. And instead, no, they've only made the conclusion that they wanted to catch the car, and now that they caught the car, they don't have any further plan. Old people never consider consequences. They know they're going to die before those consequences happen, or that they're at least insulated from the consequences because they have money, because they're older, and they have a position as a Supreme Court justice, which means, there's never going to be anything in the world that affects them. Anyway, that's what I have time for today. I love you all. Thank you for coming. Thank you for your support, and I will see you in the videos that drop. I swear to God, I swear to the God I don't believe in that I'm going to get those videos out and get started again. I am just recovering still. So anyway, I love you. and I'll see you in the next one.